Know the Law web series ku Swagatam. Today's subject is whether the subordinate courts can initiate contempt proceedings in the event of disobeying any orders passed by the Honorable Court. Before going to discuss about the powers of subordinate courts, let us discuss what is contempt and how many contempts are there. Contempt, the intention of the legislative body in bringing this act is to secure the confidence of people in the administration of justice. There are two types of contempt. One is civil contempt, another one is criminal contempt, which are clearly defined in section 2B and 2C of Contempt of Courts Act 1971. What is civil contempt? If the party to the proceedings violates or breaches the order or judgment or decree or any representation, any undertaking given by them before the Honorable Court, that's called civil contempt. Criminal contempt means if any publication is made scandalizing the courts, lowering the image of the courts, and making any unwarranted or derogatory remarks about the court, about the presiding officers, that comes under criminal contempt. As per the Act, the maximum punishment, that is simple imprisonment for a period of 6 months or a fine of rupees 2000 or with both. If any contempt proceedings initiated by the party to the suit or petition or the Honorable Court suo motu can make a reference to Honorable High Court for taking appropriate action in the matter under section 15 of Contempt of Courts Act. The trial courts, that is the subordinate courts, have no right of initiating any contempt proceedings, which is clearly held in a judgment of Delhi High Court in the case of ICICI Bank versus Rashmi Sharma. Again, I am repeating, ICICI Bank versus Rashmi Sharma. In that case, the Honorable Delhi High Court categorically and clearly stated that the subordinate courts have no right to initiate any contempt proceedings. The trial courts, that is the subordinate courts, shall make a reference to that effect before the Honorable High Court. Then the Honorable High Court will conduct inquiry under Contempt of Courts Act. In this matter, the Delhi High Court categorically stated that the subordinate courts has no right of initiating any contempt proceedings. That is settled law, sir. That is the reason if any party wants to move an application before the subordinate court, they can do so. But the subordinate court has no right of conducting any inquiry or issuing summons to the party, to the erring party, that is to the contemner, under any circumstances, except to making a reference to the concerned Honorable High Court. The Honorable High Court alone is having jurisdiction to decide such matters. In another case, Chitra Woods Manor's Welfare Association, Shaji Augustine. Again, I am repeating the case law. Chitra Woods Manohar's Welfare Association was Shaji Augustine. This is the recent Supreme Court of judgment. In that judgment, the Honorable Supreme Court clearly stated that in the event of violating the orders of the Honorable Court, certainly the court can initiate contempt proceedings, only High Court or Supreme Court. Only both High Court as well as Honorable Supreme Court alone is having jurisdiction to decide such matters. In that matter, the landlord filed a suit against the tenant for eviction, but the tenant failed to deposit the arrears of rent amount in spite of the court directions. In those circumstances, the Honorable Court initiated contempt proceedings. Only the Honorable Supreme Court and High Court alone are having jurisdiction. The question arises in this matter, even after disposal of the case, whether it is decreed or dismissed, the contempt proceeding shall go on. Because of the suit or decreed or dismissed, it doesn't mean that the party has no right of initiating any contempt. I am relying upon one judgment which is reported in Srimati Priya Chauhan. This is the Madhya Pradesh High Court judgment. In that judgment, clearly, categorically stated that mere decreeing the suit or dismissing the suits doesn't bar to proceed with the contempt proceedings. So, even after disposal of the cases, that is case, whether dismissed or decreed, the contempt proceedings shall go on. In another judgment, in reference versus Vijay Chaudhary, this is the judgment of Madhya Pradesh High Court, which is clearly stated, if any person violates the or breaches the court orders or raises any voice against the presiding officer or scandalizing the courts are making any derogatory remarks in the petitions filed by them before the court, certainly they are liable for the punishment mentioned in Contempt of Courts Act. So a person is not supposed to, a party to the proceedings is not supposed to raise his voice in the court making some derogatory remarks against the presiding officers. So in that matter, the presiding officer has referred the matter to Madhya Pradesh High Court, and Madhya Pradesh High Court has decided the matter, punishing the contemner. Raising voice and making derogatory remarks against a court is certainly amount to contempt, and such person is liable to be prosecuted under Contempt of Courts Act. What is the limitation? Is there any limitation for filing a contempt application before the Honorable Court? There is a 1 year time granted by the Act to initiate contempt proceedings. And from the date of cause of action, within 1 year, you have to initiate contempt proceedings. If you fail to initiate any contempt proceedings under 1 year, such application cannot be entertained by the court. Malla vache varam, malla kaludam vere subject tho. Thank you very much.